The Canadian Foundation for Labour Rights held a seminar on the Ontario Supreme Court's recent ruling denying Ontario farm workers the ability to associate. I spoke with Michael Lynk, the Associate Dean at the University of Western Ontario's Faculty of Law, about the Fraser decision and what this ruling means for the future of labour law.
The Fraser decision was a challenge by Ontario farm workers to be included in some form of detailed statutory scheme that would give them effective collective bargaining rights and the right to be able to organize. They had been granted that for about 18 months in 1994. They lost that with the new Ontario government in 1995, and they'd gone to the Supreme Court once in 2001, where they received a decision saying they had to be given some sort of rights. The Ontario legislature didn't pass a new Agricultural Employees Protection Act saying they were able to present requests to employers for collective bargaining, but there's no obligation on the employers to bargain with them, let alone try to find reach a collective agreement. They challenged that as unconstitutional. It went to the Supreme Court, and in April 2011, the Supreme Court said, we don't have enough evidence in front of us to establish that the new process by this 2002 legislation is actually unconstitutional. So the farm workers' challenge to the new legislation was turned down on an 8-1 vote.
What does the Fraser decision mean for unions?
For unions right across the country, Fraser means for them either nothing, because they can isolate that decision, say it really only had to do with the lack of constitutional evidence in this one particular case, or it may actually represent the beginning of a sea change, that perhaps the courts are getting more conservative and the courts are getting less interested in wanting to give detailed content to the freedom of association right that's in the Charter of Rights and Freedoms. Is
this detrimental to Section 2D of the Charter?
I think a lot of people who care about labour rights and who are interested in seeing a robust Section 2D freedom of association being recognized by the courts will think it's rather disappointing that this decision came to what it did. It didn't say agricultural workers, who are among the most vulnerable employees we have in our society, didn't get positive recognition from the Supreme Court that their exclusion from an effective collective bargaining regime meant something. So it's disappointing for those who care about labour rights to look at them. For the broader movement, we'll have to wait and see whether or not courts pick that up. But courts do stay attuned to what the Supreme Court is saying. And courts were giving a more robust version of Section 2D since 2001 or 2002. For the Supreme Court now to say, whoa, maybe we went too far with this, or maybe we're going to demand a much higher standard from trade unions for the kind of constitutional evidence they need to present, as opposed to someone who's asserting criminal rights or someone who's asserting freedom of expression. That may send a message to the courts below that perhaps Section 2D is really sort of the poor sister of the Charter, that it doesn't have to be sort of nourished and read broadly and expansively. So we're in a wait and see stage now, but in 2 or 3 years' time, it may well be that we're beginning to see a more distinctively negative trend by lower courts, or we're going to see the lower courts ignoring Fraser. My sense, if I was a betting man, would be to say that we are going to see a more conservative tone coming from courts in the aftermath of Fraser.
Are there any benefits as a result of this decision?
Governments and employers had argued at all levels of the courts, including the Supreme Court, that they didn't want to see an expansive definition on Section 2D in this particular case, and that the legislation set out by the Ontario government for agricultural workers was sufficient to allow them to bargain collectively in a meaningful fashion. So for those employers who argued that, and for those governments that didn't want to see a broad infringement of their right to pass the kind of labour legislation they may want to pass, this for them would be seen as a victory, as a more sensible interpretation of Section 2D, and as a means to allow them to a fairly wide freedom to how to pass legislation in the future.
What about labour lawyers? Does the Fraser decision pose any problems for them?
Labour lawyers always are looking at where the Constitution is going with respect to this. For them, the courts have made a more conservative move in the last 20 years when it comes to constitutional rights and Section 2D. And for us, we pay attention to the minutiae of what the courts will wind up saying. It's worrisome. We've seen a more conservative trend coming from the Supreme Court in the last 10 years than perhaps there was in the 1990s. With respect to trade unions, this casts the whole debate of, should we be going to the courts? Should trade unions be going to the courts to advance our rights there? We can't get them through the legislature. And when the courts come down with what trade unions would say are disappointing decisions, or decisions that don't show much understanding of what trade unions do, it diminishes the faith of an important institution, trade unions, in what is one of our most important features of government, which is the courts. So we're going to see this tension in the next little while as to unions deciding, do we continue with a judicial legal challenge route, or do we ignore the courts altogether and find out some other way of defending our rights or asserting our rights? And that will be an interesting feature what Fraser winds up giving to us.